Hello, I'm Tessa Sullivan. I'm a lawyer and officer of the Supreme Court of Victoria and am currently undertaking my second Master's on a scholarship at Harvard University. I'm also an academic marker at the University of New England. Today, I'll discuss the changes to the Sex Discrimination Act and Fair Work Act. The Sex Discrimination and Fair Work Respect at Work Amendment Bill of 2021 would amend the 2009 Fair Work Act and the 1984 Sex Discrimination Act. The objective is to strengthen anti-discrimination and industrial relations frameworks to better protect employees from sexual harassment and other forms of sex discrimination in the workplace. The bill implements the federal government's response to a number of recommendations in the Sex Discrimination Commissioner Kate Jenkins' Respect at Work report for the Human Rights Commission. This follows an early announcement where the federal government agreed either wholly, partly, or in principle to all 55 recommendations. In addition, the bill also proposes the extension of existing compassionate leave entitlements to include miscarriage. This would entitle an employee to up to 2 days of compassionate leave if they or their current partner suffers a miscarriage. For this presentation, I will outline the changes to both acts. Firstly, the key proposed changes under the Fair Work Act are as follows. The bill would amend the Fair Work Act to include a new legislative note inserted into the Act itself, informing readers that sexual harassment in connection with the employee's employment can be a valid reason for dismissal. The anti-bullying jurisdiction in the Fair Work Act would also be amended to clarify that the Fair Work Commission can make an order to stop sexual harassment in the workplace. Secondly, the key proposed changes to the Sex Discrimination Act are that the SDA would be amended to create a new object clause making it clear that in addition to elimination of discrimination and harassment, it aims to achieve, so far as practicable, equality of opportunity between men and women, and includes a new provision inserted to explicitly state that it is unlawful to harass a person on the grounds of their sex. Further, the coverage of the Sex Discrimination Act would be expanded to ensure its provisions align closely with the terms used in the Model Work Health and Safety Law, and to protect more people from sexual harassment, including volunteers and interns. The bill would also clarify that victimizing conduct can form the basis of a civil action for unlawful discrimination, in addition to a criminal complaint under the Sex Discrimination Act. And the time frame for when a complaint can be made to the Australian Human Rights Commission would be extended under the Sex Discrimination Act to 24 months after the alleged unlawful conduct took place, replacing the 6-month limitation currently in place. So, in summary, the Sex Discrimination and Fair Work Respect at Work Amendment Bill 2021 will clarify that sexual harassment can be a valid reason for dismissal under the Fair Work Act, clarify that harassment on the basis of sex is prohibited under the Sex Discrimination Act, broaden the scope of the people covered by the Sex Discrimination Act, including volunteers, interns, and self-employed persons, clarify that a victimization complaint can be considered either a civil or criminal matter, and extend the time frame for which complaints can be made to the Human Rights Commission. In addition, it will amend the Fair Work Act to allow an employee to take compassionate leave if they or their spouse or de facto partner have a miscarriage. So what are these implications for the employers, and what does it mean? These changes will have a significant impact on the employers and their complaints processes. For employees, it will essentially mean that employment documentation and policies will need to be amended to reflect changes to the law regarding sexual harassment and miscarriage, compassionate leave, which may involve industrial organizations, if a workforce uses an enterprise agreement. 2, it means that the complaints processes will need to be reviewed and amended to reflect changes to the law. Thirdly, it will mean the complaints processes will need to be reviewed to ensure that organizations respond effectively to sexual harassment claims and complaints. And fourthly, training will need to be conducted with employees so that employees understand changes to the law and its consequences for workplace conduct. Thank you so much for listening.